Ladies and gentlemen, welcome today to our seminar, our training on the importance of intellectual property when doing business abroad. It's a pleasure to tell you a few practical tips on intellectual property, which our expert Valentin Delecour will deliver in a couple of minutes. But before we go into the technical parts, just a few words about the services of the Helpdesks. These are free initiatives of the European Commission to help SMEs better understand intellectual property, which is so incredibly important when doing business abroad. Here you see a few things, a few elements of the services that we offer. We have an inquiry helpline, which is an actual email address where people can write anytime with any questions they have regarding intellectual property. We organize a lot of workshops. This is a great example. We do webinars. We have a great website and a blog, various guides and fact sheets on various topics of pertinence to intellectual property. It's very important to keep following us on our social media. You see here the various details to get updates on new legislations and new issues of importance to intellectual property rights. It's very important to mention that there's 5 IP SME helpdesks. There's one for Europe, covering intellectual property in Europe, but also 4 geographical helpdesks that cover issues of IP in 4 geographical areas. You can see them here. We cover Latin America, China, recently India was added, and we have Southeast Asia as well. So any question for these regions, don't hesitate to contact us. Before I give the floor to Valentin, just a quick word of introduction. Valentin Delecour has been an expert with the Helpdesk for many years. He's a qualified lawyer working for the law firm DALDEWOLF and has many years of experience working and supporting SMEs with their intellectual property in various markets, focusing on trade secrets and other aspects of intellectual property. And Valentin, the floor is yours.
Thank you, Jim, and well, hello everyone. Very happy to be here and to have the opportunity to talk about intellectual property in the context of internationalization. Here is the overview of my presentation, and well, as an introduction, I would like to say a few words on the context and remind how important intellectual property is in today's economy. First slide, I think it's important to remind you what intellectual property is and why was it created. Well, very broadly, IP refers to the creations of the human mind. So it protects intangible assets that need to meet certain conditions. For example, an invention, in order to be patentable, needs to be new, inventive, and industrially applicable. Now, IP rights have been created in order to protect the interests of innovators and of creators. And how do you do that? Well, by granting them exclusive right. I will explain what this notion, very important notion, means. But basically, the idea is to give a monopoly on the creations, on the innovations of the IP right holder. And through that exclusive right, well, a company will be able to exploit its intangible assets. And IP rights will be the basis, well, for example, to grant licensing agreements, licensing authorizations to use your IP with, in return, well, of course, the payment of royalties. IP will also be the basis to enable a company to protect its intangible assets and to fight back, for example, in case a company faces counterfeits. And so the ratio, the idea behind IP, is to enable a creator to exploit its innovations, its creations, and to get a return on its investment, on its investments. So it's really, the idea is to incentivize innovation. IP has become more and more important. It's not a scoop. We evolve nowadays in a knowledge-based and innovation-based economy. An innovation where, well, what gives value to a company is not its material assets. It's not the computers, the land, the vehicles of a company that give its value. It's its people. It's its ideas. It's its capacity to innovate and to protect the results of its innovation. And how do you do that? Well, through intellectual property. Now, IP is extensively used nowadays by the largest companies in the world. It's really considered as the most important asset of the world's largest and most powerful companies. As pointed out, it is the foundation for the market dominance and continuing profitability of leading corporations. And so, well, the biggest companies nowadays invest massively in their innovation, of course, but in protecting the result of their innovation by using IP. Now, why should SMEs, smaller companies, care about IP? Why should they invest in the protection of their intangible assets? Well, many reasons for that. And I've listed here a few of the reasons. Well, I think the first one is, of course, to protect your competitive advantage. You invest in the development of a unique and relevant technology. It gives you an advantage over competition. Well, you want to protect that. IP has been created for that by granting exclusive rights. A second reason is attract investments. You're a startup, a scale-up, you need investment to international, you need money, cash to internationalize. You want to knock on the doors of venture capitalists. If you do not have a relevant IP strategy, if you do not have a relevant IP portfolio, they won't even look at your file. Third reason, freedom to operate. Freedom to operate, or FTO, as we say in the IP world. It's basically by developing a relevant IP strategy and IP portfolio, you can significantly reduce the risks that are linked to technology commercialization. Reduce the risk of infringing the rights of others, of your competitors, for example. And this is, of course, true at home, but obviously when you go abroad, when you internationalize. Fourth reason, increase control when you outsource. Let's take a typical example. You have developed an innovative product. You have to source and have manufactured high-tech components in China, for example. You have to identify a relevant partner. You have to communicate that partner very sensitive information to enable him to manufacture your technological components. Well, if you have a relevant IP portfolio that also covers China, it will reduce the risks that this partner will start using the information you communicate to work, for example, for your competitors. Another reason is, of course, tax purposes, and in Belgium we have a very interesting IP box regime. So that's another reason why IP should be used and invested in. And last but not least, well, IP can be the key when you enter new markets. It will make your company more attractive if you want to develop partnerships. It will also help you secure your position on new markets. Now, what do we see in practice? Well, unfortunately, we see that very often SMEs, younger companies, scale-up startups are less focused on IP. And very often, SMEs perceive IP as a cost, not as a profit center. They perceive IP as a nice-to-have, not a must-have, as big corporations do. And this leads, unfortunately, to a loss of competitiveness of many SMEs. A lack of focus in IP, well, that may lead to a loss of business, loss of revenues, it may lead to damage your reputation, eventually it may lead to a loss of competitive advantage. And so it's really worthwhile, well, understanding what IP is, understand how IP can support your business, especially if you internationalize and you go abroad. Of course, that needs to define a strategy. This needs proactivity. This requires to start early. This requires to be aligned with your business strategy and with your internationalization strategy. Never forget that IP is not an end in itself. It's always there to support the growth and the protection of your business. Now, let's say a few words on the main types of IP rights and on the notion of trade secrets. Basically, protecting your intangible assets, well, you can do that through two ways. The first one are intellectual property rights, talking about patents, trademarks, design rights, copyrights. And they all function in the same way by granting exclusive rights to the holder of these IP rights. I will come back to this notion. Second way are trade secrets. Now, trade secrets are not intellectual property rights per se. They don't grant you an exclusive right, but they protect you against unlawful acts. An unlawful acquisition, disclosure, use of your confidential information. Now, what is interesting is that the core principle of intellectual property are more or less harmonized worldwide, because most of the countries are part to international IP treaties and agreements that have been existing for many, many years. And so, well, you have a common understanding of what a patent is worldwide. But of course, the way that is translated into law, the way that is implemented into practice will vary greatly depending on where you're active. And so it's very important to have a local approach and a strong understanding of how the IP system works in the countries where you want to internationalize. Now, how does IP work? Well, let's take the examples of patents. Well, a patent will grant you an exclusive right on an invention. So the object of a patent is an invention. It's a technical solution to a technical problem. For example, it could be how to better store energy in a battery. Well, you can develop many ways to do that, and it's a technical problem. You can find a technical solution because you improve that capacity. It can be patentable. Now, to be patentable, you need to answer several conditions, several requirements. Your invention must be new, inventive, applicable industrially. Very important, keep this in mind. When it comes to IP, very often the protection is not automatic. You have some exceptions, copyrights, for example, but keep in mind that basically you need to ask to be protection. And when it comes to patent, well, you need to file a patent application. Then you go through a whole registration process, and if your patent is granted, well, then it will be granted by a state. So a patent is territorial. Right? It's not because you have a patent in Belgium that you're protected in India, and the protection is granted for a limited term. And so if you have your patent granted, well, you will have exclusive rights that are granted. What does that mean? Well, you will have the right to exclude others from making, using, offering for sale, selling the invention without the patentee's authorization. So that's the whole idea of IP. It's enabling you to have a monopoly, an exclusive right on the exploitation of the object of your right for a patent, an invention. Now, a few statistics. Interesting patents, of course, are widely used. In Europe, 1 in 5 patent applications are filed by an SME. So patents are massively used by SMEs. And you have a constant growth in patent applications originating from Europe, including a growth of patent applications originating from Belgium. Now, how do trade secrets work? As I mentioned already, a trade secret is not an intellectual property right. What is the object of protection? Well, basically, trade secret can protect a wide variety of information. Like a patent, it can protect technical information. For example, an invention that was not patented can be kept secret and protected through trade secrets. But it can also protect commercial or financial information. For example, a client list, a supplier list, a marketing strategy, an acquisition plan, an investment plan, an internationalization strategy can all be protected through trade secrets. Now, here again, you need to meet certain requirements, certain conditions. The information must be confidential, of course. It must have economic value because it's confidential. And you need to be able to prove that you adopted reasonable steps to protect the secrecy of the information. So basically, keep in mind, trade secret protection is not automatic. You need to proactively protect the secrecy of your information. No title granted, no exclusive rights, protection against unlawful acts. As I mentioned already, unlawful acquisition, use, and disclosure. The example, you find a manufacturer in China. You communicate technical plans so that he can manufacture your product. You label the plans as being confidential. You sign an NDA with that Chinese partner where you basically define what he can do and cannot do with the information you've communicated. And he, for example, he uses it in breach of the contract for a competitor. Well, you will be able to act and to benefit from the trade secret regime. Keep in mind that IP rights and trade secrets are complementary and they're massively used by innovative firms. Now, second thing to understand is that IP rights, well, you have different types of rights and they all serve different goals. Trademark, for example, that will protect the indication of origin of your goods and services. It's a sign that enables you to distinguish your products from those of your competitors, so it will basically protect the brand identity of an organization. Second, patents, mentioned it already, it protects inventions, so a technical solution to a technical problem. Designs, well, they protect the external aspect of a product. For example, the design of an iPhone, for example, can be protected by design. Copyrights, they protect creative works. That's a very broad notion. It goes from, of course, artistic works, literary work, movie, but it also includes computer programs, databases, technical drawings, promotional material, all that can be protected through copyright. And then last but not least, trade secrets. As I just mentioned, confidential information, a broad notion, can cover data, algorithms, source codes, client lists, etc. Here is a brief recap of the different, the main IP rights and trade secrets, with a recap of what they can protect, what are the conditions, what are the formalities, what is the term of protection. I'm not going to elaborate on this, you will get the slides, but it gives you a brief overview of what we're talking about. Let's come to the core of our topic of today. Well, how do you protect your intangible assets when you enter new markets? First thing, and it may seem totally obvious and common sense, but if you want to protect something, you need to know what you have to protect. And intangible assets, where they're non-physical, sometimes they're difficult to identify. And very often, well, companies, big and small, but especially smaller ones, they don't have a clear view of what their intangible assets are. And so it's difficult to protect them, especially when you go international. So very often SMEs lack an overview of their IP assets. They don't know what are their IP assets. They don't know the value of these IP assets. They don't understand the added value that they can generate with their IP assets. And so very important to have a comprehensive overview of your IP and to conduct an IP audit to understand, well, if your products and technologies are protected, how they are protected, to understand, well, what protection is relevant for your business, and then for all your IP assets, well, important to ascertain the legal status, the territorial coverage, the value, the related risks. And based on this first assessment, based on these audits, well, you need to define your strategy. First thing you will have to define, well, and understand is, well, what do you have to protect and how can you protect it? Okay? And basically, of course, you need to focus on the IP assets that are interesting for your business. What IP assets are essential to achieve your business goals? What is the expected return on investment? What are the risks related to a specific asset? What is the budget to protect it? All these you need to take into consideration, define your strategy, and of course, prioritize your protection needs. When it comes to exporting, when it comes to internationalization, of course, a key focus is the territorial coverage of your IP portfolio and strategy. So a few questions to ask yourself. What are your markets of today, of tomorrow, the must-haves, the nice-to-haves? What are your competitors' markets? Maybe it's relevant to develop an IP portfolio there to block them, for example. Where are your potential investors located? You're looking for money. For example, you turn to China, even though it's not a market interesting and relevant for you. Maybe actually it is. Maybe you have Chinese investors willing to invest in your company, and having an IP portfolio in China will definitely help you to do that. Where will you manufacture or outsource the development of your technologies and products? Again, the example, you outsource a component to be made in China. Really important to have a strong IP portfolio there, even though it's not an interesting market for you. And again, I mentioned it already, but always align your IP strategy on your business strategy. Keep in mind that IP is there to support your business. Step 3, very important, to create a bundle of rights. Don't limit yourself to one single IP rights. Too often, I meet young SMEs, they think that they have an IP strategy because they filed a trademark and they didn't look at the design of their products, they didn't look at the technical solutions, the patentability of their products or technology. That's a big mistake. Keep in mind that the more IP you have, the better equipped you will be to face sometimes very challenging situations on market abroad. And so understand that, well, one same object, for example, a very simple biscuit packaging, can be protected by different types of IP rights. And if you look at it, well, these are all the different elements of the packaging that could be protected through IP. Now, the goal, of course, is not to invest in the protection of all this, but you get my point. Layer your IP. Don't limit yourself to one single type of IP rights. Step 4, important to have enforceable IP rights. And I mentioned it already, but I insist, an IP right is territorial. What does that mean? You file the patent applications in Belgium. Guess what? You're not protected in India, you're not protected in the US, you're not protected in China. So important to cover the countries where you will trade, where you will manufacture, where you will exhibit your product. Think about trade fairs. Think about the countries of your competitors, possible investors, and do a strategic analysis. First thing. Second, keep in mind registration is needed. With some exception, IP protection is not automatic. I really insist on that. It's important to understand that. And to understand that you need to register on time, okay? Developing an IP portfolio is not something you improvise. You need to plan ahead, and you need to apply for protection on time. Otherwise, sometimes it's not possible anymore to be protected. And keep in mind as a general principle that not applying for protection in a specific country, well, that means that you give a free license to use your product, your technology, your brand, your design to third parties, to your competitors, okay? That's very often not something you want to do. And then last but not least, I mentioned it already, I insist, adapt to local specificities. Step 5, don't forget your trade secrets. I talked about it already, so very briefly, keep in mind, no automatic protection. You need to proactively protect the secrecy of your information, and know that over the last years, all trade secret protection regimes have been significantly reinforced in the US, in Europe, in China. So the major economies around the globe, you have a better trade secret protection regime today than you had just five years ago. And then the last step that is extremely important is to pay attention to IP in your contracts. Contracts are absolutely key to successfully protecting your IP abroad. Coming back to this same example, you want to have your products manufactured in China. You communicate sensitive information, technical drawings, a lot of confidential know-how in order to have your products manufactured as you want. You don't want that information to be used with competitors. So important in your manufacturing agreement to have a strong confidentiality clause that defines what your manufacturer can and cannot do with the information you disclose. Important also to have an IP clause, a strong IP provision. Again, very often, for example, a Chinese manufacturer will work on your product. He will develop here and there a few things, and he may improve your products, improve your technology. If you didn't organize this by contract, the risk is that your Chinese manufacturer will own the IP in the improvements he made on your request, paid by you. Okay? So very important to have strong IP and confidentiality clauses in your agreement. And keep in mind that IP and confidentiality, trade secrecy, is relevant to numerous contracts, of course, technology contracts, of course, trademark and copyright licensing agreements, but also manufacturing agreements, distribution agreements, employment agreements, consultancy agreements may have a very important IP and confidentiality components. So, bottom line, understand what you have to protect and negotiate your contracts in great detail in order to have it protected as you want. Now, last part of my presentation, a few tips, few local tips and things to know from the various IP help desks. Let's start with China. I'm personally very much active. I used to live and work in China and work with China on a daily basis. 2 slides. First one, important to understand a bit of the context. Important to understand that, well, in China, the Chinese IP landscape has changed. It has changed for the better. Today, China is the #1 country in the world when it comes to the number of patent, trademark, and design applications. In 2019, for the first time, China became the #1 country for Pct applications. What is a Pct application? Is basically, to put it simply, an international way of filing patents. So that means that Chinese companies, well, they file at home, a lot of domestic filings, but they more and more file abroad and develop IP portfolios abroad. China is the most IP litigious country in the world and basically understands that innovation has become of strategic importance for the country, that R&D spending is massive in China. They are going to surpass the US in the coming years. So a country that invests massively in innovation means that it needs IP, because IP has been put in place to protect the result of innovation. And so bottom line, well, IPR has become essential for Chinese companies. And so today the country has invested in a modern and pretty well-functioning IP system. Not perfect, some differences over the country, but basically you have all the tools necessary. Few things to say, running out of time. Local specificities, maybe one quick word on utility models. Utility models are kind of small patents. They cover smaller technical improvements of products. Basically, the inventiveness requirement is lower than for invention patents, so it's easy to obtain, it's cheap and quick to obtain. It gives you the same rights as a normal, I would say, invention patent, and the potential of utility models is totally underestimated by foreign businesses. Chinese companies massively use the utility models, they apply for it a lot. Foreign businesses, absolutely not. Same thing for Chinese design patents. Potential underestimated by foreign businesses. Interesting to know is that you have a new patent law that will enter soon into force in 2021, and that extends the duration of protection from 10 to 15 years. Important to seek trademark registration sooner rather than later. China is what we call a first-to-file country. It means that the first entity that applies for registration, for trademark registration, will become the legitimate owner of that trademark. So if you don't register your trademark in China, but a Chinese company did it, the day you go in China, you will face a third party that owns and that is the legitimate owner of your trademark, and that can get you into a lot of trouble. Very easy to avoid. Register on time. A few words on Southeast Asia. I think the first thing to insist is that you cannot approach Southeast Asia as one entity. You don't have a Southeast Asian IP system, so you need to have a strategy that is adapted to the requirements of each country. Patents, well, you do have patents, of course, in Southeast Asia. You have a principle of absolute novelty and first-to-file system. You can apply nationally or use the Pct application system. You do have some countries that also have utility models, as I just explained for China. So take advantage of it. Trademarks, again, no global protection system. You need to register your trademark in each country where you will be active. It's also a first-to-file system. And basically, you can go for national trademark applications or use the Madrid system, which again is an international way of applying for trademark protection. Copyright, important. Most of the countries, if not all, are member of the Berne Convention. It's an international copyright treaty, according to which, well, basically, copyright protection is automatic. So if you create, you develop, you code a software here in Belgium, you should be, in theory at least, be protected in Southeast Asian countries. Design rights are also available. Latin America, first thing to understand, same thing basically. You don't have a Latin American IP system, so you need to understand each Latin American country, well, how does it work there? Interesting to note is that not all Latin American countries are members to the relevant international IP treaties and agreements. So it's not really up to the international standards in several Latin American countries. Important to know is that you need a local domicile to apply for IP protection, which means that you have to work with local agents, with local IP lawyers. Important to do that, and important to work with good lawyers. You can have huge differences, so get advice on that. Registration proceedings, the duration of registration proceedings can vary a lot between the countries, and it can be pretty long. And also, duration of protection of several IP rights can be different in one country to the other. So, lack of homogeneous IP system in Latin America. India, and I will finish with this. Well, basically, all the main IP rights can be protected there. Patents, you have the same registration requirements. Novelty, inventiveness, industrial applicability. Term of protection is 20 years, cannot be extended. You have, if you meet certain conditions, you can have an accelerated proceeding to have your patents protected. Industrial designs. Interesting to know is that you don't have unregistered designs, as we have in Europe. Trademarks, well, you do have registration requirements. What is interesting with India is that it is not a first-to-file country. It's a first-to-use country. So the first user and the first documented use of a trademark in India entitles you to trademark protection. And then possible also in India to register your copyrights. Now, to conclude, one last slide, one last recap, where I would like to summarize what you should keep in mind when you go international. First thing, I hope you understood that you have to align your IP strategy with your international ambitions. Keep in mind that European SMEs with strong technologies and strong brands also need an IP strategy to protect these technologies and strong brands that will make them more competitive, more valuable, and that will create way more opportunities. And second, well, define a tailor-made IP strategy, adapted to your company, adapted to your ambitions, adapted to your internationalization strategy. And that requires to be proactive. So start early, define your strategy, know what you have to protect, so perform an audit, register your IP rights in the different territories where you want to be active, layer your IP, don't limit yourself to a patent, don't limit yourself to a trademark, use all the tools that are available to protect your competitive advantage, adapt to local specificity, so always understand how it works in the different territories where you want to be active. Don't forget your trade secrets. And last but not least, negotiate your contracts in great detail. That's it. Thanks a lot for your attention. And well, I will be very happy to answer any questions that you may have.